Okay, well, morning. My name's Daisy Jones. I'm an associate here in the employment team at Fox Williams. And today I'm going to be giving you a bit of an update on restrictive covenants. So what we're going to start by doing is just running through some of the basic principles of covenants, what they are, where you can normally find them, and the key legal considerations in terms of drafting them, before moving on to look at a few recent cases we've had in this area. I'll then finish up with some practical considerations for you all to keep in mind when you're looking at covenant issues. So we're going to trot through the first few slides relatively quickly because I'm sure most of you will be familiar with the basic principles of covenants, but I just want to make sure that we're all sort of starting on the same page. So in essence, restrictive covenants are provisions which, if they're enforceable, will prevent employees from doing particular things after they've left your employment. So we normally expect to find these in the employment contract itself, but sometimes they are included in other documentation. So if you've acquired or sold a business recently, you might find that there are covenants in the purchase documentation, because it's often part of the commercial deal that key senior individuals sign up to covenants as part of an acquisition so that they can't then damage the value of the business that's been acquired should they leave. Now, employers also sometimes choose to include covenants in incentive arrangements, so you might find covenants packaged up with, say, restricted stock units, equity option awards. This is something that's more commonly seen in the States, but we do see it in the UK as well. So I think just to bear in mind, just because you don't have covenants in an employment contract doesn't necessarily mean they're not lurking somewhere else. So in terms of the types of covenants we normally see, I'm sure most of you have come across all of these. Now, you might find the straight non-compete covenant, i.e. something that prevents an employee from being engaged or involved in a competitive business for a particular period following termination. Other common covenants will perhaps focus on protecting the former employee's workforce. So you might find covenants restricting solicitation or employment of certain key employees going forwards. And then there's sort of a third typical bucket of covenants that we see, which will focus on protecting the employer's relationships. So whether that's with clients, with customers, with suppliers. So they're what you typically would see as covenants preventing employees from actively soliciting those relationships, or indeed from dealing with these third-party entities altogether. And now the advantage, if you think about the non-solicitation versus the non-deal covenant, is that if you include a non-dealing covenant, what that should do, if it's enforceable, is stop the former employee from actually doing business with the third-party entity, so with your clients, with your customers, with your suppliers, even if they've not actively solicited that work. So if the third party approaches them, a non-deal covenant should stop them from actually accepting that work. So those of you who have taken legal advice on covenants will no doubt have been told that the issue with them is that although they're a very useful tool to protect your business, they can be quite difficult to enforce, particularly if the restraint goes further than the courts are willing to allow. So take, for example, a non-compete covenant. Here, the effect on the employee of that covenant is really quite serious. It can, in certain markets, stop the employee from actually going out and getting another job for the duration of the covenant. And because of that public policy reason, the courts will really test whether or not they think the covenant is enforceable. The impact on the individual is so severe, potentially, they need to be satisfied that the covenants meet the legal tests. So when we're thinking about enforceability, the key legal principle we're focused on is that the restriction should go no further than is reasonably required to protect the legitimate interests of the former employer. So as a general rule of thumb, the broader and more general the drafting of your covenants, the more difficulty you're likely to encounter in trying to enforce them. So we touched on this a little earlier, but I've set out on the slides the kind of key business interests that you might be trying to protect with your covenants. The first one we've got is trade connections. The most typical covenant you would use to protect that would be the non-solicitation, non-dealing of third parties, so your clients, your customers, suppliers, depending on your type of business and the role that the employee was carrying out. The second type of interest we tend to see protected is stability in the workforce. So there, what you would be looking at is non-solicitation of employees who have left your non-solicitation of employees by the departing employee after they've left. And then the final kind of key interest we see people looking to protect is trade secrets and sort of proprietary confidential information. And to protect that sort of interest, normally what you would be looking to use is a non-compete covenant. So, as I mentioned earlier, covenants can be quite difficult to enforce, and this is particularly the case if they're drafted too widely or too loosely. So we're going to spend a few minutes going through some of the key considerations a court will take into account when they assess enforceability. So I think the first really important point to think about is that courts will look to the reasonableness of the covenant at the time it was entered into, not on the date that you're actually seeking to enforce the covenant. So, for example, if you've had an employee in your business for 10 years, they come in as a fairly junior employee, and at that point in time, you stick into their contract kind of fairly onerous covenants, but maybe they're the covenants you use for everybody in your business. The employee stays with you for 10 years, and then when they leave, you look to enforce those covenants that you put in 10 years ago. Now, what a court will do is consider whether or not your covenants were reasonable for the junior employee who joined, not for the more senior employee who is now leaving. So that, I think, is just something that's really important, and I think you need to then be considering as staff move up through your business, are their covenants still appropriate? Do they need to be refreshed? Do they need to be revisited? The second area to think about is the employee's status, because what you really want to make sure you're doing is putting in covenants that reflect the role and the position of the employee in question. You know, generally, the more specific you can be, the better. And if you think about it, I suppose, the covenants that you would need, say, for someone who is a salesperson, will be completely different for someone who might come to you and work in like a research and development role. So if, say, taking the example of the salesperson, if they leave, what's the risk to the business? Well, I think the obvious risk is going to be they pitch up to the competitor and they try and bring their kind of relationships that they've had maybe with your clients over to that competitor. So what you're likely to want is a non-solicitation, non-dealing covenant that captures those trade relationships that the individual had. If you've got someone that works in research and development, the danger zone is likely to be around the sort of confidential or proprietary information that they've acquired. So what you're wanting to, a non-solicitation of clients or customers isn't going to be any good for you there. So what you're probably wanting to think about is some kind of non-compete restriction instead. Now, it's also really important to think about your covenants in the context of your own market and your industry, because a court will look at that when they're trying to work out if they think the covenant is enforceable. So again, to use the example of a salesperson you've hired, you're thinking about what covenants you want to put in their contract. Well, assuming they're a good salesperson, as we've said, the risk to you is around customer relationships. They leave and they take those relationships with them. So we're thinking, again, the non-solicitation, non-dealing type covenant. Now, the importance of thinking and reflecting on your own business and kind of market and industry standards is to work out how long you think that covenant should last for. So if in your business, and we're still using this example of a salesperson, you meet with your customers, say, on a fortnightly basis, a court will think, well, how long is it going to take you, once your salesperson has left, to actually bed back down with those customers? If you're meeting them every 2 weeks, maybe that's a month that you need, that's 2 meetings, or maybe it's 6 weeks, so it's 3 meetings. But you need to really think about what length of time you realistically need to kind of re-establish that relationship. If, however, you only meet your customers, say, every 6 months or every 12 months, then obviously a 6-week non-solicitation covenant isn't really going to be very much good to you, because actually during that 6-week period you won't have had an opportunity to rebuild those relationships. So I think it does all turn on a case-by-case basis, but you want to really be reflecting your business, and if there are any sort of industry standards that are adopted, what they might look like as well. So typically, say in the insurance sector, we see lots of covenants that run on a 12 or a 13-month basis, and that's all driven by the fact that in insurance, typically you get a 12-month renewal on policies. So we've touched on duration a little bit already. As a general comment, the shorter the duration of the restriction, the easier it's likely to be to enforce it. And this goes back to the fact that courts will only enforce covenants which go no further than is reasonably necessary to protect your legitimate business interest. So if you want an enforceable covenant, it can sometimes be better to err on the more conservative side in terms of the duration of the restriction, particularly where you're using non-compete covenants. Again, the reason for that is the impact on the individual of a non-compete can be really serious, so courts really test them much more carefully than they might a non-solicitation. So you might find that you can have a longer period for a non-solicitation covenant, but on the non-compete, we would generally see them being shorter. Turning to geographical scope, it can be tempting to draft your covenants so that they apply, for example, anywhere in the world or anywhere in the UK on a bit of a just-in-case basis. Now, really what you want to do is limit the scope of the covenant so that it only applies to those geographical areas where the employee worked and is therefore capable of damaging your business interests in a real way. Because if you stray beyond that, again, the risk that you're under is that a court will say, actually, you don't need the covenant to apply globally, and actually on that basis we think it's not enforceable. Now, just finally on this slide, turning to harm caused, as I previously touched on, a court will be much more circumspect about enforcing covenants which have significant negative impacts on the individual. So, as I say, that's why we tend to find non-competes as being some of the more difficult covenants to enforce. So it's often worth thinking about, when you're drafting your covenants, if you want a non-compete, can you, as a fallback, also have some kind of workable non-solicitation covenant that might give you some extra protection if your non-compete fails? Because, as I say, the non-solicitation and non-dealing type covenants tend to get a slightly easier ride from the courts when compared with the non-compete covenants. So we're now going to look at 3 recent cases on covenants, and we're going to give some thought about whether or not they're enforceable. Now, I had planned some audience participation. It strikes me looking at your slide packs that you probably can see the answers to the questions. I will ask the questions anyway. If you want to play honestly and not look at the next slide, then that would be lovely. If you do cheat, I would never know. So just as you like, really. The first case we've got here is the case of Rush and Gibson Forbes. So here, Rush Hair, there's one, I think, down on Moorgate. It's a line of hair salons. It bought 3 hair salons from Miss Gibson Forbes. They entered into a share purchase agreement, and under the terms of the share purchase agreement, Miss Gibson Forbes agreed that she wouldn't solicit certain employees from the business for a period of 2 years after completion of the deal, and similarly, she wouldn't actually enter into a kind of a competitive business within that 2-year period as well. Now, what Miss Gibson Forbes then did was she incorporated a new company, she became a director of that company, and she set up a new competitive salon, and she employed the former chief stylist from the Rush Hair Salons to be her chief stylist. So the question I have is, do we think that covenant is enforceable? So can I have a show of hands for yes, we think it's enforceable? Okay, yeah? And anyone going for no? Okay, so what we've got, for those of you who didn't look ahead, we have an enforceable covenant here. Now, in this case, there are a few interesting facts just to draw out. There was a question before the courts as to whether or not the covenant would be enforceable because Miss Gibson Forbes had incorporated a new corporate entity, so she incorporated that limited company through which the breaches took place. Now, actually, the court wasn't persuaded that taking that step, say by removing herself and kind of hiding behind this corporate entity, that she'd taken herself outside of the covenants. what the court found was actually Miss Gibson-Forbes would habitually run her salons through the medium of a limited company. And when actually the parties signed up to the covenants, it would have been in their minds that that was a way she was likely to run a business. And as such, what the court said was that if we interpret the wording of the share purchase agreement, even though it didn't expressly envisage her setting up this new limited company, actually the parties would have thought that might be realistic. So the covenant should bite both on her personally and on her kind of corporate entity that she acted as an agent for. Now the court then looked at what Rush hair salons had actually purchased and whether or not there was an interest that could be protected by the covenants. And here what the court found was that part of what they'd acquired was the goodwill in the business, and in this sort of industry that goodwill was the personal connection between the stylists and their customers. And the court went on to conclude that actually this 2-year non-compete and non-solicitation of certain key stylist covenants was enforceable. Now I think it's interesting that we've got a court judgment upholding a 2-year non-compete and non-solicitation covenant, and that's useful I think if you're thinking about covenants in the context of a share purchase agreement. But what I really want to stress to you is that the covenant was enforced in that share purchase agreement context. You shouldn't take from this judgment that you could have a 2-year non-compete covenant in an employment contract. So I just, where we are with the courts at the moment is that that duration really won't be acceptable. But when you're dealing with share purchase agreements, the whole sort of bargain and arrangement is quite different. And the general rule is that courts will be more tolerant of longer restrictions in a share purchase agreement compared to in an employment contract. So, got our case number 2. Now, I quite enjoy the facts of this case, although I did have to be corrected when we were discussing this in a technical meeting as to which side of the country Blackpool was on, because I got that completely wrong. But what we've got here is Mr. Harrison. He is a Michael Jackson tribute act. He was employed by the Sands in Blackpool, and he performed in their tribute show. Now, Mr. Harrison left the Sands in October 2015, and he went to join the Central Pier Company, and they ran their own tribute show called Kings and Queen. Now, these shows were seasonal. There were a few that would happen over Easter, but the main season was kind of over the summer starting in June. Now, Mr. Harrison had a 12-month non-compete restriction in his covenant with the Sands, and so having left in October, in June of 2016, the Sands then sought to enforce that covenant. So, got another show of hands. Who thinks this covenant was enforceable? Okay, and who thinks it wasn't? I don't know if we've got cheaters in the audience today. You're all right, you're doing very well. So, no, the court wasn't enforceable. The covenant wasn't enforceable. In arriving at this decision, the court didn't really focus on the language of the covenant itself, but on the timing of the application to enforce. Now, the courts found that the Sands had actually timed their application so that, if granted, it would be really very damaging to the Central Pier. Making the application in June would effectively have prevented the Central Pier from being able to run their tribute show as they had rehearsed it. It was open to the Sands to have made its application in, say, February or in March, but they chose not to do so, and the Sands gave no good reason for that delay. And the court found in those circumstances it wasn't prepared to enforce the covenant. Now, I think, as I say, the story might have been different if the Sands had decided to try and enforce sooner. But I think the takeaway point for you all is that if you are considering enforcing a restrictive covenant, you ought to take steps to enforce as soon as you're reasonably able to do so. And you shouldn't really try and be too tactical about the timing of your action and how it might impact on a third party, because that may be taken against you. Right. So then in our final case, we've got Mr. Thornton, who was an agronomist. He joined Bartholomew's as a trainee in 1997. He then resigned in December 2015 to work for a competitor. Now, his original 1997 contract contained the restrictions set out on the slide. So that's a 6-month restriction from being engaged in work or supplying services which compete with the employer to the employer's customers, or from working for a competitor. A little bit unusually, the covenant also contained language that said he would be paid for the period of the restriction, even if he got another job, provided he wasn't breaching those covenants. Now, as I say, Mr. Thornton left, he went to join a competitor in December 2015, and Bartholomew's applied to the court to enforce the covenants. So this is your final question. Who thinks the covenant was enforceable? And not? Very good. Yes, they were not enforceable here. Now, the first point and issue, as we've talked about earlier, was the date on which these covenants were entered into. Now, you might remember I said the courts will look at the reasonableness of the covenant when they're signed up, not when you're trying to enforce them. Now, here the covenants were in Mr. Thornton's trainee contract from 1997, and incredibly, they hadn't been touched for the entire duration of his employment until December 2015 when he left. And the court said actually these sorts of covenants were manifestly inappropriate for a trainee agronomist in these circumstances. Now, notwithstanding the problem around the date on which the covenants were entered into, the court also found that the language was far too broad. The covenant applied to all customers, irrespective of whether or not Mr. Thornton had worked for them. And typically, if we were advising on drafting, what we would suggest is that you limit the scope of your covenants so that if you have, say, a non-solicitation or a non-dealing with customers or clients, it only bites on those customers and clients that the employee has had material contact with for a particular period preceding the termination. And one final point to note is just on the fact that the covenants allowed him to be paid for the duration, and this made no difference at all to the court's determination on enforceability. Now, those of you who perhaps have colleagues in continental Europe might come across this idea of paying out restrictions. It is something that is done in certain jurisdictions on the continent habitually. In the UK, it makes no difference in terms of enforceability at all. So the only upside really to offering to pay the covenant out is that you may find the employee less likely to object to it if you're going to do so. So before you're released for coffee, just a very quick kind of sum up of some practical considerations to keep in mind when you're thinking about covenants. So I suppose the first thing is to carefully assess the risk areas relating to that individual's employment. If you can draft covenants on an individual basis, so much the better. What you really want to be thinking about is what harm could this particular employee do to our business? Did they have access to proprietary information? Are they going to be able to go off and help a competitor with that if they leave? Did they have really strong relationships with your clients, your customers, your suppliers? Are they likely to be able to move employees with them? And when you've done that sort of risk assessment, then you can draft your covenants accordingly. As I say, when you're thinking about duration, think about actually how long, say if it's trade secrets you're worried about, how long are those trade secrets likely to be relevant for your business? Because there'll become a point in time when actually they're no longer sensitive, it's old information if you like, and you should be pegging, say, your non-compete covenant to the duration in which that information remains live. Similarly, we've talked about how long, if they've got really good customer relationships or client relationships, how long do you need as a business to re-establish those relationships? And again, try and peg your non-solicitation or your non-dealing covenants to that duration and time. Keep covenants updated to reflect changing risks. So, as we've seen from the case of Thornton, as someone moves through your business and becomes more senior or goes into a different role, you should be revisiting the covenants. Did they still work for you? Do you need to refresh them? If you are going to introduce or change covenants during employment, you need to make sure that you agree that with the employee contractually, and also you need to make sure that there's some kind of consideration passing from you as an employer to the employee. So whether that's kind of a particular bonus award, a promotion, a pay increase, you need to peg it to something. You can't just put it into a letter and get the employee to sign if you're not giving anything in return, because a court will find that actually that's not enough to make those covenants enforceable. I popped on the slide, beware a one-size-fits-all approach. It's really tempting as businesses, I think, to have covenants that you use for everyone. That's much easier to manage. The difficulty is if you end up trying to enforce a covenant and the employee can say, well, I've got this covenant, but so does every other single employee in this business, a court is going to find it much more difficult to believe that actually that covenant is appropriate for the individual in question. So whether you have tiered covenants depending on seniority or different covenants on a department by department basis, the more specific you can be, as I say, much the better. And then a final point to leave you with, just be a bit careful when you're terminating employment. One thing to make sure you do is to terminate in accordance with the contractual terms, so whether that's kind of serving notice, paying in lieu of notice. If you don't terminate in accordance with the terms of the contract, arguably the whole contract falls away, so then you lose the benefit of any restrictive covenants that you've got in there. Okay?